Good evening. My name is Jane Spinnick, and on behalf of my co-chair, Nancy Polikoff, and myself, we welcome you to this symposium. We are especially pleased that we were able to reschedule the symposium this spring after the postponement in March. I'm going to say more about the symposium in a few moments, but two others would like to add their welcomes. The first is the Dean of Columbia Law School, Jillian Lester. Nancy and I would both like to thank Dean Lester for her commitment to this symposium, both spiritually and financially, and for her joining us tonight. Dean Lester?
Thank you, Jane, and to all of the audience today and our panelists, welcome. Over the past several years, we've seen a reckoning with systemic racism in the United States, as well as a vehement backlash to immigration policies that separated children from their families at the US-Mexico border. This conference is designed to shed a light on a set of issues at the intersection of these two issues, as well as a related issue that we need to be talking about just as much. All of you know that for decades, state agencies that oversee child welfare have separated children from their families. And more often than not, this means separating Black and brown children from their parents of color. We're now at an inflection point. A system that should safeguard children is falling short. And the question that's put to all of you as leaders and advocates is, how can we do better? How can we design a system that empowers children and families without tearing them apart? How can we support those who are struggling in our society without punishing and incarcerating them? These are the difficult questions, along with others, that will occupy the collective wisdom of the distinguished and thoughtful group that is gathered for today's conference. I want to recognize Professors Jane Spinnick and Nancy Polikoff, as well as Nicholas Galvan and the entire board of and the staff of the Columbia Journal of Race and the Law, for your tremendous efforts in putting together this wonderful program. I know that this symposium was long in the making. We've started it twice, or tried to start it once before. And even though we can't host it on Columbia's campus, we're no less thrilled to see such robust participation here today. I should also acknowledge that the journal plans to publish 2 issues devoted to these proceedings, which will be an additional important contribution to the public conversation. And I want to thank all of you who are here with us. It's rare to see such a large and diverse coalition of academics, practitioners, advocates, and students, as well as parents and youth, come together to tackle a set of problems this important. Advocating for children and families has long been an area where Columbians, we at Columbia Law School, have devoted our efforts. And I'm thrilled to see that this continues in a proud tradition here today. Thank you again for attending, and welcome once again to Columbia Law School.
Thank you, Jillian. Thanks for those words of support and encouragement, and thanks for acknowledging the difficult task we have ahead. Now I'd like to introduce the editor-in-chief of the Columbia Journal of Race and Law, Nicholas Galvan. Nico and the symposium editor, Jacob Elkin, have been wonderful partners in ensuring the success of the symposium and in their willingness to dedicate 2 issues of the print journal, along with articles and blogs published online. Nico?
Good evening, everybody. I'd like to express my gratitude and then say a few words before leaving your screens. Thank you, Dean Lester, for your support of our journal and for supporting our professors and their work. Thank you, Professor Spinnick and Professor Polikoff, for leading the symposium from its inception to today, and for choosing to co-host with our journal. Thank you, Professor Roberts, for all that you do. Thank you for paving the way for all of us and for being a beacon in this space. I'd also like to thank the entire board and staff of the Columbia Journal of Race and Law, and a special shout out to my managing editors, Jake Elkin, Vinay Patel, and Jennifer Romero, who have led the journal's efforts for the symposium and devoted 2 issues and over 500 pages of original scholarship to this work. I'd finally like to thank the authors, the panelists, and the attendees who dare to interrogate the family policing system and reimagine what child welfare truly means. Now I'd like to say a few words. We live in the time of George Floyd. May he rest in power. We are in the time of Ferguson. We are in the time of Time's Up. And we are in the time of defund the police. And we are also in the time of COVID-19. The pandemic, in addition to the great loss of life many of us have witnessed, has put a magnifying glass upon the existing structural inequalities permeating our society. Thankfully, we are nearing the end of the pandemic, at least here in the United States. But let us meet this moment. Let us embark on what this moment needs of us. We, those who are guaranteed equal protection under our laws, must meet this moment by examining, deconstructing, and refining the systems that are no longer fit for our contemporary society. Sometimes, this inquiry leads us to no other solution than to dismantle and abolish the systems that constitute us as a body politic, and we must radically reimagine those systems. Today, we begin that process. Today, we say enough is enough to the systems that we were given. Today, we meet the moment by daring to imagine new ones. Thank you all for coming. Thank you for all that you do. Muchísimas gracias para todo. Lo agradezco mucho. And I hope you all enjoy our symposium.
Thank you, Nico. Thank you for those inspiring words, and thank you again for the great partnership that you and Jake and the entire CJRL staff gave to us. Before I say more, I'd like to acknowledge the lands Columbia Law School is on with a brief story. When I went to elementary school in the late 1950s and early 1960s, I learned the names of the European conquerors and colonizers who came to these shores and destroyed the lives of the native nations who populated the Adirondack foothills where I grew up. When my daughter went to elementary school, she learned of the Lenni Lenape people who lived on the land on which her school was built. This may seem like a small step forward, but I know it helped to shape her understanding of her place in the complex society in which we live. I hope by acknowledging and recognizing the Lenni Lenape and Wappinger peoples, whose original nations comprise the lands on which Columbia University is built, will help all of us participating virtually today to understand our places in this society. We also want to thank others who have helped put this virtual gathering together. Nancy and I have relied on Michelle Ellis to coordinate programmatic information, which she has done often in the evenings and on weekends and twice over. You've gotten a lot of emails from her. Thank you, Michelle, for your dedication to this symposium. Two members of the law school's IT team have been key to our launching the symposium. Luis Bello has worked with us every step of the way, and Franz Marin swiftly fixed many of our problems. The production team, led by Steve Francis, along with Andrew Newcomb, Mas Yamagata, Lee Taylor, Igor Belitsky, Ramon Estevez, and Enrico Benavente, have been terrific in setting up our virtual platform and leading us through the process. Thank you all for your work and support and bringing us to a place where we can host over 2,000 registrants. I also want to thank our panelists and especially our moderators for the hard work they did 2 times over to prepare for this symposium. We are so appreciative of your commitment to making this symposium an important step in transformative action. Finally, while Nancy will say more about our keynote speaker, I want to thank Dorothy Roberts. One of my cherished memories is of walking around Charleston, South Carolina with Dorothy many decades ago, taking a break while we were working with medical advocates in South Carolina who were trying to stem the criminalization of pregnancy. Tragically, that remains another ongoing fight, but the afternoon itself was a special one. Dorothy, Thank you for all you have done to lead us to understand that the current child welfare system neither protects children nor supports their well-being, and to allow us to use the occasion of this symposium to commemorate the 20th anniversary of the publication of Shattered Bonds. Now I'd like to turn for a moment to the symposium itself. The idea of story shapes what I want to say tonight. In a TED Talk in 2009, the writer Chimamanda Ngozi Adichie warned of the danger of the single story. She recalled how when she was young, she saw the boy who worked for her family only one way, as a poor boy who needed charity. When she went with her family to visit his village, she was shocked to realize that poverty didn't define his family. They were so much more than the single story in her head. In the family regulation system, we suffer from the danger of the single story, really two stories. The first is of the poor, vulnerable, incapable family who has no strengths or agency, and thus their children need to be saved from them. The second story is a savior story of the people who come to fix that family and save their children. We create a double narrative of the helpers and the helped, the savers and the saved, the worthy and the unworthy. This double narrative has infected family regulation from slavery through Jim Crow to today, needlessly destroying Black families. This double narrative has allowed Native children to be torn from their families and nations and sent to boarding schools, foster homes, and institutions. It has propelled immigrant children to be sent thousands of miles away from their homes and families. It has destroyed generations of all kinds of families. This double narrative punishes parents and children ostensibly for their own good, and repeats what one of the panelists tonight, Laura Briggs, has called the enduring, devastating American practice of taking children. One of the purposes of this symposium is to defeat that double narrative. Adichie says that all stories are about power. She says how they are told, who tells them, when they're told, how many stories are told, are really dependent on power. So part of what we are doing in this symposium is providing a forum for more stories to be told so that power shifts. We have brought together parents and youth, activists, organizers and advocates, academics and practitioners to unlearn and learn, to pay attention to what Peggy Cooper Davis once called neglected stories, and to acknowledge how strong the movement to abolish family regulation has become. To illustrate this change, I want to say some names. Sabra Jackson, Jeanette Vega, Sandra Killick, Teresa Batchelor, and Hope Newton. These are some of the women I have known over the past 20 years who have been on the front lines of destroying the story of family regulation. They are the mothers who had the courage not just to tell their stories in all their fullness and complexity, but to use them to make the family regulation system begin to listen and even to change. There are also youth and young adults who told their stories. Jessica Maxwell, Daniela Rinhover, Melody Ceteno, April Curtis, and Leda Garcia Greenewalt, who is speaking here tonight. Having been separated from their families, they took the opportunity first to challenge the narrative of being saved, and then to work with other system-involved youth and adults like themselves to organize, to protest, to create, and build a different vision of what child well-being means. I acknowledge and honor them tonight because without their willingness to speak out, to speak up, and to become fierce advocates for themselves and their communities, along with hundreds of others like them, we would not be here tonight. Yes, many of us so-called professionals also took steps to challenge family regulation, to create new forms of legal advocacy, to challenge laws and policies, to write new legislation and rules, to author articles and books, and to teach new generations of social workers, doctors, lawyers, therapists, and journalists. But to do that and to do it well, we had to listen, to acknowledge, to begin to share power and authority, to unlearn in order to learn. Less than 3 weeks after we issued the call for papers for this symposium, a Minneapolis police officer murdered George Floyd, a murder that 17-year-old Darnella Frazier captured on video and broadcast to the world. Just last week, Ms. Frazier was awarded a special Pulitzer Prize for her video. The mass protests that followed in cities and towns around the country brought systemic racism to the forefront of American consciousness at a time when the COVID-19 pandemic was disproportionately devastating BIPOC communities. They also turned the demand for police and prison abolition, a movement decades in the making, into a serious topic of mainstream conversation. Reconsidering how systemic racism and white supremacy impact the purposes and practices of traditional institutions was legitimized in ways that hadn't been widespread throughout the country since the Civil Rights Movement. That legitimacy was apparent in the scores of proposals we received and in the content of the papers and panels that comprise this symposium. This is the moment, as Nico said earlier, to solidify our resolve not to reform but to transform, to abolish the child welfare system and re-envision child well-being. This is the moment to defeat a tragic double narrative that has debased and devalued and destroyed families with the false pretense of helping them. Please listen carefully to the ideas that you will encounter tonight and over the next 2 days, and consider how you will join a movement to support the well-being of all children and families. I'm now going to turn the program over to Nancy Polikoff, who will introduce our keynote speaker, Dorothy Roberts, and moderate the responding panel. Thank you.
Thank you so much, Jane. Jane has offered extensive thank yous to many members of the Columbia staff and other people. So that leaves it to me only to thank her for her work to make this event happen. The seed for this event was planted 3 years ago at a Law and Society meeting where Jane spoke on a panel, along with our keynote speaker, Dorothy Roberts, and other longtime family defense advocates, Diane Redleaf, Ruth White, and Richard Wexler, whose weekly news and commentary roundup on the website of the National Coalition for Child Protection Reform is required reading for anyone wanting to stay current in this field. It was at that panel that I heard Jane use the word abolition in the context of discussing the problems with the family court. The answer, she said, was abolition, and a light went on in my head. We began our collaboration in the months after that, leading up to tonight and the 2 days ahead of that. It has been a pleasure to work with you, Jane, and I look forward to your book on abolishing the family court, forthcoming from NYU Press. Thank you. It is my honor to introduce our keynote speaker, Dorothy Roberts, and the 4 panelists who will respond to her address and present their own exemplary work: Gwendolyn Alfonso, Laura Briggs, Penthea Burns, and Leda Garcia Greenewald. After Professor Roberts speaks, we will hear from each of the responders and then open it up to a robust discussion among all the speakers. If you have questions for the group or for any individual speaker, please write them in the questions area at the bottom of your screen, and we will get to as many as we can. Dorothy Roberts is the George A. Weiss University Professor of Law and Sociology and the Raymond Pace and Sadie Tanner Moselle Alexander Professor of Civil Rights at the University of Pennsylvania. She holds joint appointments in the departments of Africana Studies and Sociology and at the law school. She has authored 3 books, co-edited 6 books, and written more than 100 scholarly articles and book chapters. If Professor Roberts' work was known only within academia or only among lawyers, she would still be a superstar. But her influence extends much farther than that. Activists for reproductive justice, which includes the right to parent children in safe and sustainable communities, read, discuss, and use her work as they develop their agenda and as they formulate actions. We are here tonight and over the next 2 days to commemorate the 20th anniversary of Professor Roberts' groundbreaking book, Shattered Bonds: The Color of Child Welfare. If the problems that Professor Roberts described in Shattered Bonds had been adequately addressed and remedied in the last 20 years, we might be here taking a victory lap, but that is far from the case. So tonight, Professor Roberts will describe her contemporary vision, a preview of her latest book, which will be published next year and is tentatively titled Torn Apart: How the Child Welfare System Destroys Black Families and How Abolition Can Build a Safer World. Dorothy?
Thank you so much, Nancy, for that introduction. Thank you to Dean Lester for hosting this symposium. I'm so grateful to my longtime friends and comrades, Professors Nancy Polikoff and Jane Spinak. Thanks, Jane and Nancy, for reminding me of how long we've been working together. Thank you for spearheading this symposium. And thank you to the editors at the Columbia Journal of Race and Law for bringing us together and publishing the papers. Thanks to all the brilliant and dedicated participants who are contributing to this symposium and all the people out there who are joining us. I've learned so much from you and been so inspired by so many of you. I really am truly honored by this symposium, this opportunity to address you, and I can't think of a better way to celebrate the 20th anniversary of Shattered Bonds. I want to talk about how I became a family policing abolitionist. I first became aware of the racial realities of family policing in America when I was working on my 1997 book, Killing the Black Body. I'd been researching the prosecutions of hundreds of Black mothers across the country for using crack cocaine while pregnant. Racist myths about them giving birth to so-called crack babies who were described in the press and even in scholarly journals as irreparably damaged, bereft of social consciousness, and destined to delinquency and criminality. Those myths had turned a public health crisis into a crime. I saw the prosecutions as part of a long legacy of oppressive policies originating in slavery that devalued Black women and denied their reproductive freedom. That's when I discovered that thousands of Black mothers were having their newborns taken from them because of a positive drug test, and realized that child removal was even more widespread and in many ways more devastating than the prosecutions. The system's racial divide was obvious to me as soon as I started observing child welfare proceedings in Chicago. I was teaching at Northwestern Law School at the time. As I later wrote in Shattered Bonds, spend a day at Dependency Court in any major city and you'll see the unmistakable color of the child welfare system. Dependency Court is where judges decide the fate of children who've been taken into state custody because their parents were charged with maltreating them. Nearly every family in these courts is Black. If you came with no preconceptions about the purpose of the child welfare system, you would have to conclude that it's an institution designed to monitor, regulate, and punish poor Black families. 20 years later, Black communities are still targeted for child welfare intervention. Although Black children were only 14% of children in the United States in 2018, they made up 23% of children in foster care. More telling are recent data indicating children's chances of landing in foster care at some point while growing up. According to a 2014 study, about 15% of Native children and 11% of Black children could expect to enter foster care before their 18th birthday. The rate for white children, about 1 in 20, was remarkably lower, reflecting America's racial hierarchy, but still incredibly high. I spent time with Black mothers whose children had been taken from them and learned that what's called child protection is no social service system. It's a multi-billion-dollar apparatus that relies on terrorizing families by taking their children away or weaponizing their children with the threat of removal to impose intensive surveillance and regulation on them. In my introduction to Shattered Bonds, I concluded, the color of America's child welfare system is the reason Americans have tolerated its destructiveness. It's also the most powerful reason to finally abolish what we now call child protection and replace it with a system that really promotes children's welfare. In this keynote, I want to renew my call to abolish the family policing system that I wrote in Shattered Bonds 20 years ago. But this time, I don't argue for replacing it with another reformed state system. We need to build a radically reimagined way of caring for children and their families. 3 things happened since the publication of Shattered Bonds that solidified my abolitionist perspective. There were numerous reform efforts to reduce what became known as racial disproportionality in foster care. The prison abolition movement expanded, and organizing by parents and children impacted by the system strengthened. Since I wrote Shattered Bonds, racial disproportionality has become a buzzword in child welfare research and policymaking. State child welfare departments and nonprofit organizations have launched numerous projects across the nation to reduce the foster care population along with its racial disparities. Over the last 2 decades, I myself participated in many of these reform efforts to improve foster care. I served for 9 years on a task force to implement the settlement agreement in a class action lawsuit brought in 1998 by children's rights advocates against the Department of Social and Health Services, DSHS, in Washington State. The lawsuit was called Brom versus State of Washington. The department's treatment of children in foster care was so horrendous that the children's lawyers claimed it violated the state constitution. The named plaintiff, Jessica Brom, had been tossed among foster homes more than 30 times. In 2004, after 6 long years of litigation, the children's attorneys reached an agreement with DSHS in Washington to resolve the lawsuit by handing the problems over to a panel of 5 mutually agreed upon national experts. I accepted an invitation from the children's attorneys to be one of their choices. We called ourselves the Brom Oversight Panel, and we worked with DSHS, Children's Administration, and the children's attorneys to develop a complicated plan with outcomes, benchmarks, and action steps to improve healthcare for children in foster care, lower CPS worker caseloads, enhance foster parent training, and decrease the number of children who ran away from foster care. Then, for nearly a decade, we monitored the state's progress in performing the action steps, meeting the benchmarks, and achieving the outcomes. After dozens of meetings with administrators and attorneys at a hotel across from the SeaTac airport, I became far too familiar with, we calculated some progress on some of the measures, but we weren't able to fix the long list of deficiencies that harmed children placed in state's custody. The Brahms settlement isn't exceptional. Over the last 30 years, states across the nation have been sued for running child welfare systems that severely harm children, even kill children. The child welfare departments in numerous states are currently governed by court-monitored agreements arising out of class action lawsuits, requiring them to make massive reforms. While some systems have failed for decades to live up to the old settlement agreements, others are continuously brought to court for the same problems endemic to foster care. The Illinois Department of Children and Family Services is operating under more than 10 consent decrees, one of which was filed in 1988. As child welfare departments around the country have shrunk their foster care populations, although some are going back up again in response to fiscal and justice concerns, they've simultaneously expanded their invasion into the private lives of marginalized communities through investigations and coercive service provision. Under federal law, every state must identify mandated reporters, people who work in professions that put them in contact with children, such as teachers, healthcare providers, social services staff, and daycare workers, and require them, under certain circumstances, to report suspected child abuse and neglect to government authorities. CPS treats these reports like accusations to be investigated, not requests for help. Mandated reporting drives parents from the very service providers that are most likely to support them. Enlisting service providers in CPS surveillance deters families from seeking needed assistance and ruins their relationship with families, weakening their capacity to improve children's welfare. Providing services within a punitive family policing system thwarts the potential for schools, healthcare clinics, and social programs to be caring hubs of community engagement that non-coercively and far more effectively help families meet their material needs. And the racial disparities in family surveillance persist. More than half of Black children are subjected to a CPS investigation at some point during their childhoods. Most Black children will be investigated by this policing system. I learned that trying to reform the system can strengthen it. We can't tinker with the flaws of a system designed at its roots to police poor, Black, Indigenous, immigrant, and other marginalized families as a way of maintaining a racial capitalist system. The second thing that happened in the 20 years since Shattered Bonds was published was that the prison abolition movement expanded dramatically. Some activists mark its launch at an international conference and strategy session, Critical Resistance, Beyond the Prison Industrial Complex, that was held at the University of California, Berkeley in September 1998. Formed in 1997, the Critical Resistance Organizing Collective gathered more than 3,500 activists, former incarcerated people, lawyers, and scholars over 3 days to, quote, address the alarming growth of the prison system, popularize the idea of the prison industrial complex, and make abolition a practical theory of change, close quote. Since then, the prison abolition movement has grown into an influential framework and network of organizing across the nation. This past summer, as protests erupted around the nation and the world in response to continued police violence against Black people, the call to defund police and abolish prisons began to make more and more sense to more and more people. The family policing system is part of that same carceral regime. Like the police and prison systems, family policing is designed to maintain racial injustice by punishing families in place of meeting their needs. It targets Black, Brown, Indigenous, and immigrant families in particular, and it relies on racist beliefs about family dysfunction to justify its terror. And it's entangled, deeply entangled, with police, criminal courts, and prisons, forming a coherent carceral machine. As I was drawn into prison abolition, it became clear to me that the movement to abolish police, prisons, and surveillance was profoundly connected to a less visible movement to end family policing. I found three central tenets that are common to formulations of abolitionist philosophy especially useful. First, today's carceral punishment system can be traced back to slavery and the racial capitalist regime it relied on and sustained. Second, the expanding carceral system functions to oppress Black and other politically marginalized people in order to maintain that racial capitalist regime. Third, we can imagine and build a more humane and democratic society that no longer relies on caging people to meet human needs and solve social problems. These tenets lead to the conclusion that the only way to transform our society from a slavery-based one to a free one is to abolish the prison industrial complex and create a world where, to answer Angela Davis's question, prisons are obsolete. Prison abolitionists have shown that the pillars of the U.S. criminal punishment system are all rooted in racialized chattel slavery. The first police forces in the United States were called slave patrols. Like overseers and slave patrols, Jim Crow police and private citizens who abetted them used terror primarily to enforce racial subjugation, not to apprehend people culpable for crimes. Today, police serve to control Black and other marginalized communities through everyday physical intimidation, and by funneling those they arrest into jails, prisons, and detention centers. We can apply a similar analysis to family policing. The origins of the U.S. child welfare system lie in the forcible separation of enslaved families, the control of emancipated Black children as apprentices to former white enslavers, and removal of Indigenous children as an instrument of tribal genocide. The whole point of the child welfare system has always been to regulate economically and racially marginalized communities. These families are targeted precisely because they are politically marginalized. Their status not only makes them vulnerable to state intervention because of the way child maltreatment is defined, to blame them for the harms to children caused by societal inequities. But family policing helps to keep them in a subordinated status by disrupting their relationships and communities. And more broadly, family policing implements an approach to child welfare that buttresses, justifies, legitimizes, excuses, fortifies this unequal social structure. Prison abolitionists have also taught us that the system's repressive outcomes don't result from any malfunction. To the contrary, the prison industrial complex works so effectively to contain and control Black communities because that's precisely what it's designed to do. Prison abolitionists have shown us that, therefore, reforms that correct problems perceived as aberrational flaws won't work. They only strengthen carceral systems. Reforming prisons results in more prisons. That's why they have to be abolished. Despite all the reforms I talked about, the family policing system hasn't changed its punitive ideology or its racist impact. By the time I became aware of the family policing system in the 1990s, the political and demographic landscape of child welfare had shifted dramatically from earlier in the century. As a result of demands to be included in government programs that Black people were shut out of, Black families were receiving greater attention from the welfare state. But as they began to fill the government caseloads, public agencies pivoted sharply from providing services to children in their homes to taking children from their families. The total size of the foster care population and the share of Black children skyrocketed simultaneously. The number of children in foster care more than doubled in less than 15 years, and federal funding for foster care increased a whopping 20,000%. I'm not adding a zero, from $25 million to $5 billion to keep children out of their families. Propelling the spike was the massive removal of Black children from their homes. Given its foundational logic centered on threatening politically marginalized families with child removal, the system has absorbed efforts to mitigate its flaws and has continued reproducing its terror. The family policing system can't be fixed. Instead, we need a total paradigm shift in the state's relationship to families, a complete end to family policing by dismantling the current system and reimagining the very meaning of child welfare and safety. Prison abolition isn't just about tearing down the system. An essential aspect of prison abolitionist theory is that eliminating prisons must occur alongside creating a society that has no need for them. As prominent activist Mariam Kaba explains, it's the complete and utter dismantling of prisons, policing, and surveillance as they currently exist within our culture. And it's also the building up of new ways of relating to each other. Prisons will only cease to exist when social, economic, and political conditions eliminate the need for them. And abolitionists are working toward a society where those conditions exist, so prisons are inconceivable. How can prison abolitionists take steps toward dismantling prisons without falling into reformist traps? They've resolved this quandary with the concept of non-reformist reforms. To be abolitionist, reforms must shrink rather than strengthen the state's capacity for violence and facilitate the goal of building a society without carceral systems. For example, efforts to stop prison expansion by opposing prison construction or shutting down prisons that already exist, ending police stop and frisk practices, and eliminating the requirement of money bail to release people charged with crimes. We can work to end mandated reporting, to give parents high-quality, multidisciplinary legal defense at every stage of the process, including before children are removed, and to fund and engage in community-based mutual aid that doesn't rely on terror by the state to support families. The third change that influenced my position on the child welfare system, family policing system, is the radical organizing by parents and other caregivers to end family policing. As that grew, with Black mothers at the forefront. I opened Shattered Bonds with the story of my first meeting with a small group of mothers who called themselves Operation Moses, for Mothers Organizing Systems for Equal Services. I first met with Operation Moses on a summer evening in 2000 at St. Stephen's Church in Englewood, one of Chicago's poorest, most segregated Black neighborhoods. After walking down the steps to the church basement, I found a half-dozen Black women sitting around a table. The women were strategizing about a citywide campaign to call attention to the crisis of Black children being removed from their homes. They greeted me warmly, grateful to have the ear of an empathetic law professor. I was noticeably pregnant with my fourth child, who was due later that month, and we instantly bonded as Black mothers concerned for the well-being of our children. At one end of the table was an expanding file stuffed with court papers, newspaper clippings, and letters. I sat at the other end so I could face everyone, and each woman told me about her battle with the family policing authorities to get her children back. Operation Moses struggled to offer mutual support to its members as each one fought an uphill battle against a seemingly immovable behemoth. In the 2 decades since, parent-led organizations sprang up across the country and began networking with each other. Coupled with the rise of parent groups was the development of family defense, lawyers dedicated to representing parents in family policing proceedings. Today, parents and youth who are impacted by the family policing system are calling for transformative change across the nation. And their calls for abolition are beginning to garner support from scholars, foundations, policy centers, and activist organizations, many of which are presenting during this symposium over the next 2 days. I think family policing abolitionists also have lessons to share with prison abolitionists. We help to show how carceral logics extend beyond prison walls and police stations, even to systems that ostensibly exist to serve people's needs, but actually exist to regulate poor, Black, brown, Indigenous, and immigrant people who rely on them. We also show how these systems resort to a variety of punitive measures to enforce compliance. Like police and prison systems, family policing is designed to serve white supremacy and maintain racial capitalism by punishing families in place of meeting human needs. And it's deeply entangled with police, criminal courts, juvenile detention, and prisons, forming a carceral machine. Warrantless home investigations, intensive monitoring of families by state agents and civilians deputized to report on parents, forcible seizure of children, followed by putting them in foster care, and permanent severing of family ties for failing to comply with agency dictates. These tactics all reflect a carceral logic with parallels in the criminal punishment system. State CPS authorities increasingly use modern surveillance technologies and coordinate with law enforcement agencies to manage regulated populations more efficiently and more cruelly. Family policing isn't just similar to the parts of the carceral regime abolitionists are working to tear down. Family policing is part of the carceral regime we need to tear down. The most prominent demand emerging from the summer 2020 protests was to defund the police and reallocate the money to provide healthcare, education, jobs with living wages, and affordable housing as part of the broader struggle to abolish the prison industrial complex. As I witnessed the protests, I became increasingly concerned that family policing was absent from most calls to defund the police. Some activists even recommended transferring money, resources, and authority from police departments to health and human services agencies that handle child protection. These proposals ignored how the family policing system surveils and represses Black and other marginalized communities in ways similar to and coordinated with the law enforcement systems condemned by the protesters. As I recently heard the amazing parent activist Joyce McMillan say, any system built to actually protect children should in no way mimic a system that tortures adults. And I don't think it's by accident that this system is set up doing the exact same thing in the exact same way as the prison industrial complex, because I see it as a prerequisite, because that many kids end up being incarcerated after. Diverting money and power to child protection agencies would result in even more brutal state intrusion in Black communities. Even well-meaning recommendations to deploy social workers to conduct welfare checks in homes would likely result in increased reporting to CPS, just expanding the state's monitoring and separation of families. Residents of Black neighborhoods live in fear of CPS agents entering their homes, interrogating them, and taking their children, as much as they fear police stopping them in the streets, harassing them, and taking them to jail. We need a coherent political analysis of carceral systems and logics that integrates our understanding of criminal punishment and prisons with the state's surveillance, reassembling, and destruction of families. We need a common mission to bring down all these extensions of the carceral state and a common vision for meeting human needs, preventing violence, and caring for children, families, and communities. Rather than feel dejected by the lack of real change since Shattered Bonds was published 20 years ago, I'm actually inspired by the confluence of these developments that point to the need to integrate movements for abolition of all the harms of the racist carceral state. We can work collectively to end family policing, reimagine the very meaning of child welfare and safety, and build a truly caring world. So, as Nico said, this is the moment. Let's get to it. Thank you.
Thank you so much, Dorothy. We are a poor substitute for the standing ovation you would no doubt be receiving if we were all in person. And I hope our audience at home is participating in that. It's my pleasure to introduce four extraordinary people who are going to provide responses to Dorothy Roberts' talk. Their longer bios are in the program on the website, so I'm going to introduce them as a group briefly, and then we'll hear from them and open it up afterwards for discussion. Gwendolyn Alfonso is trained in law and political science. She's an associate professor of politics at Fairfield University and the author of the book Polarized Families, Polarized Parties, Contesting Values and Economics. Laura Briggs is a professor of women, gender, and sexuality studies at the University of Massachusetts Amherst, the author of several books, including the recently published Taking Children, A History of American Terror. Penthea Burns is a senior policy associate at the University of Southern Maine Cutler Institute, a board member of Wabanaki Reach, and a co-founder of both Wabanaki Reach and the Maine Wabanaki State Child Welfare Truth and Reconciliation Commission. Leda Garcina Greenwald received her bachelor's in social work from the University of Illinois Champaign-Urbana, where she is currently a master's student. She spent 8 years in foster care and currently serves as the president of the Foster Care Alumni of America, Illinois chapter. I look forward to hearing from all of you.
Hi, everybody. It's an absolute delight, and I am so humbled to be part of this illustrious panel and to serve as a respondent to Professor Dorothy Roberts, whose work I've had the great pleasure of following for many years through law school, graduate school, and through my academic career now as a professor of American politics and political science. So my contribution to the symposium is going to build on Dorothy Roberts' family policing framework in the following three ways. First, like Roberts, I view child welfare as part of a larger racial family policing system that is entangled with other punitive policy systems as well, such as police, criminal courts, prisons, as also social welfare. Also, like Roberts, and I suspect almost all of us here today, my paper calls for a transformation across the nation, not only in the abolition of child welfare, but also, I would like to add, to fundamentally rethink family and politics and policy goals from a care and caring perspective, where we can value Black and brown and marginal family bonds of affection and uphold what I call the domestic affection policy standard for all population groups, not just historically privileged white family groups. And thirdly, as Roberts has stressed, the significance of political choices in public policy. And I hope to add to that political perspective by assembling a new conceptual political economic framework to explain why and how the American state has come to choose its current punitive child welfare and protection approach. So in a nutshell, here's the summary of my argument. I think it's useful to delineate two aspects of governance that was first highlighted by the French sociologist Pierre Bourdieu. Bourdieu talked about the two hands of the state, the right hand and the left hand of the state. So one side, which was the left hand, is exemplified by forms of supportive welfarist social provisions such as education, healthcare, social insurance. And then the other side, which is the right hand side, encompasses the punitive, coercive state mechanisms and policies such as police forces, criminal courts, and prisons, etc. So in the context of the United States, and with particular focus on families, my work tries to demonstrate that the left and right hands of the American state actually pivot on a combined racial policy logic of family. Who and which kinds of families are the focus and target populations of a policy? So on the one hand, the right-hand policy standard I identify as an economic utility standard that is regulatory, punitive, and focuses on Black families who are constructed and viewed exclusively in terms of maintaining and extracting their economic utility for labor markets. And the other, the beneficent standard of domestic affection, as I call it, is supportive and welfarist and focused on white families who are constructed and supported and maintained as affection-based child nurturing domestic units. And some of this extends across welfare to also things like same-sex marriage equality of today as well. So in any case, there's two different principles, utility and affection, that form the basis of this racial policy logic that has historically and contemporaneously been directed at Black and white families respectively. So at the outset, it's helpful for us to think about how Black families are discussed within congressional discourse. So for my last book on political family values, I found that congresspersons in their remarks to committee during committee hearings from 1980 to 2005, they reference over 1,100 real-life family examples as illustrations of policy successes or policy failures. Overwhelmingly, the Black families that were referenced by congresspersons were offered as negative policy examples or examples of policy failures. Something like 52.9% of these Black family examples were used to highlight negative policy developments, compared to a vast majority, something like 64% of white family cases that were used to illustrate policy successes. Moreover, 30.3% of these real-life Black family examples were those of unmarried single mother families, as compared to 2.1% of white family cases, which also suggests the correlation of Black unmarried mother families with negative policy perceptions of policy actors. It also turned out from that data that Southern congressmen were the most vocal in stigmatizing Black families in these congressional hearings, which suggested to me some sort of underlying formative impact of Southern slavery, and I started investigating that as the origins of such racial family policy logic. So I found that in the 3 decades before the Civil War, 1830 to 1860, antebellum Southern courts began to adopt a new policy standard of domestic affection. And this was based on the emerging ideology of domesticity and was used to characterize and assess white family relations. The policy standard centered on establishing affection as the natural norm practiced by white family members, particularly male slave owners, in their roles as fathers and husbands and especially masters. But at the core of the legal regime of racial slavery, and as the other side of the coin pivotal to upholding the standard of domestic affection, lay the construction, of course, of Black economic utility, the commodification and quantification of the market value of an enslaved Black person. For the enslaved, their economic value was inextricably tied to their bodies and their labor, which had distinct racial and gendered implications in the case of Black women. Unlike white women whose child rearing and contributions within their households were seen as integral to the reproduction of things like Republican virtue and civic well-being, Black women free or enslaved were only valued by the state for their economic productivity outside of their own households. So in colonial Virginia, for example, Black women were legally defined as tithable or taxable labor, whereas white women laborers were exempt from taxes. The tax on an African woman had to be paid by her master if she was a slave or a servant, or by her husband if she was married, or by herself if she was free or single. So during the antebellum period, with the rise of King Cotton, the reproduction, sexual intercourse, childbearing, and child nurturing, very fundamental aspects of intimate family behavior, I found that was constructed as inherently personal and affection-based in the context of white families in those court cases, now began to harden wholly in terms of economic value in the case of enslaved Black women and Black families. Enslaved Black women began to be priced, as Dana Ramey Barry shows, primarily as breeders as opposed to merely laborers at this time, whose reproduction and child nurturing were valued first and foremost and only in terms of their utility to the enslaver family and their property interests. So it's the economic logic that was the guiding principle. The economic utility standard naturalized Black family separations, forced sexual assault and reproduction, and child removal at every level, and courts required that agents who were disbursing human property were required to separate enslaved families based on the principle, the economic principle, that slaves sell best singly. And this, of course, continued after slavery as well. And then moving on to the 20th century, with the establishment of social welfare policy, mothers' pensions, which was the original public cash assistance program that was initiated in the early 20th century, supported deserving widowed mothers to stay home and care for their children. But right from the start, the principle and this sort of programmatic assistance did not apply to Black and brown mothers and their children and families, who were seen primarily in this economic sense. The Social Security Act further accommodated racial distribution of welfare benefits. Key Southern Democratic congressmen, committee chairs predicated their support of the bill on retaining state control over establishing eligibility criteria and enabling local Southern welfare officials to direct the vast majority of benefits to white widowed women. Benefits to Black mothers were hard to come by, meager, and very, very importantly, were intermittently withheld to coerce their participation in seasonal labor markets. So as late as 1970, Witness very proudly describes the Southern local welfare practices to a Senate committee in the following terms. He says, Black welfare recipients are made to serve as maids or to do day yard work in white homes just to keep their welfare checks. During the cotton picking season, no one is accepted on welfare because plantations need cheap labor to do cotton picking behind cotton picking machines. And from 1945 to 1965, all the way up until the 1990s, Southern Dixiecrats and their Northern allies pioneered the neoliberal discourse of the marketplace to construct poor Black motherhood as an economic pathology and advocate for their punishment in the form of welfare benefit, retrenchment, sterilization, even incarceration. Well-being of Black children. Well-being of Black children in particular, their protection from abusive and neglectful poor mothers, and their out-of-home placement also concurrently emerged as a newfound policy goal, all of which was formalized, of course, with the replacement of welfare by workfare done in the 1990s. So in our current time, the most coercive compulsory work practices continue to be directed at Black mothers and their families, and states use racial ideologies to justify and normalize higher rates of sanctioning of mothers of color, rescinding their benefits more often and more severely than white mothers. And additionally, labor market discrimination makes complying with work requirements more difficult for women of color, in turn justifying sanctions for their non-compliance. Studies have found that states with larger percentages of Black residents were less likely to provide cash assistance, but more likely to advocate funds towards the discouragement of lone motherhood. So in conclusion, the paper's historical policy analysis suggests that all reforms that devalue the affective and nurturing labor performed by Black and brown mothers in favor of their economic regulation will perpetuate racially stratified family policy ideals, obscure the unique vulnerabilities of poor Black and brown women and their families, and impede the goal of meaningful anti-racism, family support, and inclusion. Instead, as Dorothy Roberts and care theorists such as Joan Tronto and Martha Feynman exhort us to do, we must radically alter how we think of families and policy, supporting families in providing care and affection to their children as crucial state goals above all else, replacing the two hands of the state with head and heart. Thank you very much.
Good evening. I want to thank Jane Spinnock, Nancy Polikoff, and all the others who made this extraordinary event possible. It's an honor to be part of this distinguished panel and symposium in honor of the 20th anniversary of the publication of Shattered Bonds. So in the talk you just heard, Dorothy Roberts walked us through arguments against reforming the foster care system, which are in many ways akin to those against continuing to try to reform the police. In doing so, she joins many scholars and activists who have been voicing related frustrations with what seems to be an entrenched, unmovable child welfare system that engages in racialized harm to families by disproportionately separating Black, Indigenous, immigrant, and impoverished children from their parents, kin, and caregivers. Roberts points to the ways that efforts to rethink how we support and care for families rhymes with activism for prison abolition and defunding the police. When we allow ourselves to be led by the inspiration of the radical creative imagination of these movements and how they've caught fire in recent years, she argues, we can imagine caring for children without the involvement of a racist state that has demonized, impoverished, and racialized families for generations. Activists and family members involved with the system are not calling for reform. They're calling for an end to the system as we know it. As we consider the current abuses of the child welfare system, it may be useful to know that Black racial justice and Native sovereignty activists have confronted them all before in ways that offer powerful lessons for the present, in particular with respect to the dangers of reform efforts that bring more money into the system. I would tell two stories. In the 1950s and 60s, the National Urban League confronted a child welfare system that began taking Black children in order to terrorize communities fighting for civil rights, part of the White South's massive resistance to school desegregation. In New Orleans, as you all know, Ruby Bridges famously defied white supremacist crowds to be the first Black child to attend first grade in the lower Ninth Ward. To prevent her from doing so, in 1960, the state announced that it was fighting the federal school desegregation order by cutting the children of single mothers off welfare, with Governor Jimmy Davis calling their mothers prostitutes and promiscuous women, trying to force them out of state or demoralize the struggle for Black freedom by shaming those impoverished Black mothers living in sharecroppers' shacks into relinquishing children they could not afford to feed without their welfare checks. The Urban League and New Orleans Black churches mobilized an extraordinary mutual aid campaign, dropping off groceries, paying rent, and for months feeding hungry families out of church kitchens. Black newspapers across the country raised money, and as far away as the UK, people sent food for what the Urban League called Operation Save the Babies. This campaign was even more extraordinary because the National Urban League was one of the more conservative of the civil rights organizations, and their defense of welfare mothers, impoverished women who were marked as pregnant outside of marriage or who had gotten divorced, was even more surprising in 1960 than it would have been in 1996 when Congress acted to end welfare as we know it. Even so, social workers asked about the event years later remembered the desperate mothers and hungry children they encountered, without shoes, with clothes that wore more holes than garments, without glass in their windows, and with cloth seed sacks for bedding. Some, in fact, did relinquish their children in what were called voluntary proceedings, while others were forced into juvenile courts where judges took their children. Ultimately, the National Urban League, the ACLU, and others took their case to the Eisenhower administration and Social Security and demanded that it end the practice of cutting off single mothers who had children out of wedlock. Social Security denied their petition, pointing to other states that enacted even harsher rules related to immorality to punish communities in rebellion that demanded desegregation. Tennessee and Florida, for example, had mandated the taking of children from so-called unsuitable homes, while virtually every other southern state in those years after the Brown v. Board decision, and also Michigan, had taken welfare from children whose mothers engaged in what was called illegal cohabitation, adultery, or any other sexual behavior the state could figure out how to criminalize in Black communities where schools and other public accommodations were desegregating. This obviously was before the so-called war on drugs that criminalized drug use, particularly for Black mothers. We could call the 1950s and 60s the war on sex years. The compromise that the head of Social Security, Arthur Fleming, offered was this: if states criminalized sex, they couldn't just deny welfare to children. Instead, they had to give children welfare in another home, with the federal government paying for foster care. Although it took a few months to recognize it, activists' efforts to reform the welfare and child welfare systems was a disaster. Within a year, 160,000 Black children had been taken from their mothers and put in foster care. Foster care went from being a system that largely ignored Black children, preferring to let those who were orphaned or otherwise in truly desperate circumstances to circulate among relatives or go to juvenile detention, to a situation that some observers called the Browning of child welfare. The foster care system doubled in size by 1961. Reform then brought new money into the system, and that allowed states to take more children, particularly from impoverished Black single mothers. In contrast, activists for Native sovereignty largely refused reform, insisting instead that state child welfare workers get off of reservations and out of Indigenous families. Native tribal nations, in contrast, fought throughout the late 60s and 70s to get states out of Indian child welfare. The context was the federal Indian policy of tribal termination, which held essentially that tribal nations no longer existed. States and the federal government were free to enact laws that took their land. In the Dakotas, the states and the federal government built dams and rerouted rivers with the Pick Sloan Watershed Project that resulted in the loss of hundreds of thousands of acres of farmland, flooding Native homes and communities. When Native activists objected and demanded reparations, the state of North Dakota began going onto reservations and, as in the South, harassing single mothers on welfare about the conditions in which their children were living. Most lacked running water and indoor plumbing, and again, welfare workers targeted those who were not caring for their children in nuclear families. They particularly objected to the common practice among the Sioux or Dakota people of having grandmothers care for children, and tried to take children from grandmothers and place them in white adoptive and foster homes. The Spirit Lake Dakota fought back particularly fiercely. Grandmothers went to jail for refusing to relinquish children, holding tight to them while welfare workers tried to rip them from their arms. They hid children in the backwoods and under beds when they saw a new car on the reservation. The tribal council passed a resolution insisting that any cases of so-called child neglect had to be dealt with in tribal court, not state courts. Tribal Chairman Louis Goodhouse contacted the Association on American Indian Affairs, which challenged the child taking in court, winning consistently because welfare workers typically acted without any color of law. They also went to Washington, D.C. in 1968 and held a press conference at the International Press Club, where, at the height of the Cold War, grandmothers from the Spirit Lake, Dakota, invited publics around the world to scrutinize the treatment of American Indian children, winning the attention of President Lyndon Johnson. Over the next decade, the Association for American Indian Affairs played a coordinating role in what was a rapidly growing movement in tribal nations from California to Maine, with newspapers like Akwesasne Notes, Indian Affairs, and Indian Country Today featuring article after article on children taken and sometimes returned. In 1974, 1976, and 1977, the American Association on American Indian Affairs demanded hearings before Congress, and these featured mothers and children who had been separated. But year after year, a proposed Indian Child Welfare Act was defeated. Finally, in 1978, after a decade of activism, they succeeded in passing the Indian Child Welfare Act, which put American Indian kids, indigenous kids, under the jurisdiction of tribal courts. When Native children were removed from the jurisdiction of state welfare agencies and state courts, they were no longer taken in overwhelming numbers. Over the next 2 decades, the number of Native children in foster care shrank dramatically as tribal courts assumed responsibility for determining which children were, in fact, neglected. History then confirms the intuition and experience of 21st century activists. Working to end the child welfare system can accomplish a great deal, while every compromise with the child welfare system makes it stronger, brings new money into it, and reform leads it to break up more families. Thanks.
I want to echo my fellow panelists and thanking Jane and Nancy and the conference planners for inviting me to be part of this conversation with this remarkable group of women, and my gratitude for Dorothy for her comments at the beginning. I want to join her thinking about a paradigm shift and tell a story about something that's happening in a place we call Wabanaki land, or what most of us call the state of Maine. I'll begin in 1999 when Maine participated in their first federal review of the state's child welfare system, which found that Maine, like every other state in the nation, was not in compliance with the Indian Child Welfare Act that Laura was just referencing. So the state of Maine child welfare system asked the tribes to meet with them to create a training that they hoped would increase compliance with the Indian Child Welfare Act. This was the beginning of the ICWA work group, which consisted of staff from both the state and the tribe's child welfare agencies. This group worked together for many years and accomplished a lot of things, building strong relationship together as a group, delivering ongoing training, monitoring state child welfare practice with the tribes, implementing a new Indian child welfare policy in 2012, and requiring co-case management on all Indian Child Welfare Act cases, that the tribe would have the rights as a co-case manager. Despite all of this, the tribal members of this work group expressed that they just kept running into an invisible wall. And it was a wall of mistrust, and it included things like the tribal child welfare staff not being included as co-case managers, even though that was a requirement, that the tribal child welfare staff were not viewed as professionals, with state staff even expressing surprise that they had degrees or advanced degrees. And there was a belief among state agency staff that the tribal child welfare staff would, quote, side with the family. and the result would be keeping kids unsafe. The Maine Human Rights Commission even found discrimination in a specific child protective investigation implicating the investigator and the supervisor. In this Indian Child Welfare Work Group, we moved our discussions from those of policies and case reviews to about racism and oppression and intergenerational trauma. We strengthened ourselves as a group, and we strengthened our awareness of not only the issues at hand, what we could see, what was happening, but what was under the surface of that. We told our own stories, and we took care of each other. And we concluded that in order to make real change, that we needed to create a common understanding of what had actually happened in this place. The possibility of a truth and reconciliation process was introduced as a way of establishing shared understanding. And in 2008, all agreed this was a good idea. Child Welfare Agency, the Maine courts, the office, and the tribal child welfare programs. This was developed in a grassroots way. We lived it together through retreats with our convening group, engaging communities, engaging councils and their chiefs, and engaging Maine government officials as well. And in 2012, the governor of Maine and the Wabanaki chiefs signed a mandate for the formation of the Maine Wabanaki State Child Welfare Truth and Reconciliation Commission. The commission began its work a year later in 2013 with the purpose of investigating the experiences of Native people in the Maine child welfare system. Those of us, that had worked together to organize the commission formed a new organization called Wabanaki Reach, whose purpose was to support the commission in fulfilling its mandate to reach out to people in Maine and in Wabanaki communities to engage with the commissions, to perhaps share their stories, share their statements with the commission, and to support those people in the process. From the perspective of the commission, I want to talk a little bit about what they found. Half of their recommendations were specific to child welfare. Some were very technical issues like resolving funding issues and establishing more tribal courts. Others were more complex, adaptive issues like truly building an understanding and capacity throughout the child welfare system to recognize bias, to build cultural awareness, to build accountability and understanding for the broader historical context within which the child welfare system is seated. And they said, the commission said, to improve the child welfare system for Native people, that Maine and the tribes would need to confront three things. They'd need to confront the underlying racism that still is at work in state institutions and in the public. They would need to confront the ongoing impact of historical trauma or intergenerational trauma, how that impacts Wabanaki people and their communities, their well-being. And they would need to confront the differing and troubling perspectives on tribal sovereignty and jurisdiction that makes the intersection between the tribes and the state contentious. Two additional findings from the 2015 Commission report were that, one, Native children were removed at a disproportionate rate, and they saw this as evidence of continuing cultural genocide. And two, that there's continued resistance to the idea that Native people in Maine have experienced or keep experiencing genocide. They found that people from all parts of this system are exhausted. And if we don't change the way things are, it'll only get worse for the tribes in the state, which means it will really get even worse for tribal communities and tribal people. So I want to talk a little bit about what that meant for Wabanaki Reach as the commission came to these conclusions, how that influenced the direction that we went in. Wabanaki Reach began to really understand that, we started thinking that we were going to be reconciling state child welfare with tribal child welfare. And we realized that it is really a bigger piece of work with our larger society. So we seek to build a broader and stronger community of people who understand the long-term impact of the generational harms that have been done to Indigenous people since the first contact. We want to engage people who are committed to transforming the present day systems that provide advantages to people who look like me. And the work that we do falls in three broad areas. I think the most essential part of our work is around truth telling. It is the first necessary step towards healing and change. We know the firsthand that the restorative power of this process, and we've experienced it with this first Truth Commission. And in the next year, we're excited about a new truth-telling project that's focused on the land claims that happened in Maine. Another direct connection to the importance of resolving the sovereignty issue between the state and the tribes, and really intertwined with what has happened to kids and families in relation to the child welfare system as well. Our work continues to support Wabanaki well-being, supporting Wabanaki people who are incarcerated and those who are engaged in the child welfare system, also strengthening food sovereignty and outreach to communities. And we really are doing a lot of work around community education. We believe in the power of education and engagement. When people more deeply understand what happened, they innately wish to be part of writing a different history for their grandchildren, for our grandchildren. And so we prioritize doing this work, creating educational programs that help illustrate the truth of what happened across history, and that history is not in the past, but is continuing today in the way that our systems and institutions are set up. Some of the focus areas that we work on within our educational programs are working with child welfare systems and correctional systems for the people working in those systems and the families and children who are engaged in those systems. We do a lot of work with education systems, both secondary and post-secondary, the people who are teaching our children, and faith communities who are sincerely looking at the role that they've played across history with Indigenous communities and with land conservation communities. We try to organize and look at who are the different institutions and system who influence who we are as a society, what it is that we know, and what our belief systems are, and engage them in being part of writing a different history for our grandchildren. So I think that's the comments that I'd like to make for now. I want to thank you again.
Thank you all for having me today. I especially want to thank my good friend Lexi for introducing me to and gifting me Miss Roberts' book, and my mentor Carrie, who encouraged me to be a part of this very important project. It's truly an honor to sit among such talented people in their respective fields. Before I begin, I'd like to take a moment to talk about all we've lost at the hands of this system, including the lives of children like Micaiah Bryant, my sister in care, and the countless others who go unnamed and unrecognized. The idea of family policing has been around for centuries, and it's time we come to terms with our past and examine our current systems. Today, I'm going to take some time to discuss the importance of culture and how important it is in the context of child well-being specifically. After spending nearly 8 years in the Illinois foster care system myself, I can attest that the child protection system is doing exactly as it intended, policing Black and Brown families, threatening the removal of their children for what they deem as non-compliance, and erasing the culture that is the other. The United States has a history of taking a group of people identified as the other, the non-white population, and forcing them into assimilation and whitewashing. We have seen this in Native American boarding schools, the whitewashing of Christianity, and even in our history books. Of course, child welfare is not an anomaly. Corporal punishment, generally a non-white practice, is seen as inappropriate and even potential cause for removing a child out of a home. Workers and service providers, despite their cultural competence trainings, are not equipped to work with families outside of their own cultures. It's not enough to be culturally competent. In fact, it is impossible to truly be culturally competent. Nearly 20 years ago, this idea of having cultural humility came about. That is, recognizing the shifting nature of intersecting identities and the complexity of these identities. A service provider, and this includes foster parents, will never be fully competent about the evolving nature of a family or an individual's experiences. During my time in care, I had about 8 different placements ranging from traditional foster homes, kinship care with relatives, and shelters. I remember going into my first home at 12 years old, separated from my parents as well as my 5 younger siblings. While cleaning my room one day, I decided to turn on the radio, 93.5 FM. The nostalgia of hearing music in Spanish, a language native to my family, made me feel at home. Not too long into the second song that played, my foster mom barged into my room and told me to turn it off. I wasn't allowed to listen to anything that wasn't in English because no one else could understand it. Needless to say, it was a white family. It is absolutely inappropriate and unacceptable for children to feel at a disadvantage or lose their culture, their language, their identity, just because they have to spend some time in care. My siblings shouldn't have to grieve the loss of talking to their biological father because they no longer understand Spanish and have trouble communicating with him. As you all know, this is not an unusual experience. Children are being placed into homes outside of their cultural backgrounds, being forced to speak a language other than their native tongue, wear their hair in a particular fashion, celebrate holidays that are not their own. The list goes on. That is not to say that a child cannot learn other languages or learn to appreciate holidays that they don't identify with. I'm all for encouraging new learning. What I want to emphasize is that these practices should not be a replacement, but rather an enhancement to their own. This is not a broken system. It is a system that needs to be broken. It needs to be rocked to its core and dismantled. I would love to sit here in front of you today and say that the need for such a system is non-existent. We know that not all parents are meant to be parents. Mental illness gets in the way, potential incarceration, even physical health restraints. Not all parents want to be parents. We know that it takes a village to raise a child. The true issue is that many under-resourced families don't have the village that they need to raise a thriving child. In 2019, a Pennsylvania school threatened parents with the removal of their children for their outstanding lunch fees, a story that went viral. The school is known as one of the poorest districts in the state. This, of course, was not the first nor last time that foster care was weaponized as a method of getting families to buy into programming, services, or compliance. Instead of providing families with the appropriate resources to confront their demons, state agencies choose to put those millions of dollars towards foster care. Many of the families involved in the system have adverse childhood experiences of their own: homelessness, substance use, intergenerational poverty. As I continue to grow up, I encounter families just like mine who experienced intimate partner violence or substance abuse. But instead of their children being removed, the families had financial resources, a village behind them to support their healing. As a social worker and lawyer in training, I have had the opportunity to sit in on a number of child protection legal proceedings. Each time, the term best interest in regards to the child is given special importance. The ultimate best interest of the child is to be with their family, their natural biological family, a family that has been supported by their community and policies that allow them to be healthy, competent, and promising. A family that can share culture with the child, traditional foods, celebrated holidays, a shared language. I'm fortunate enough to have been a preteen going into care. My siblings were not as lucky. In the last few years, my biological mother and grandmother have passed. I feel that my lineage, a part of my heritage, has been taken from me. Still, I have memories of shared holidays and family recipes engraved into my mind and heart. I've gone back and forth to Puerto Rico, where my family is from, to further explore my culture and my family's past. I sit before you today asking you to rethink child protection, child welfare, and substitute care. What do those words mean to you? What should a system really look like? Before you answer those questions, seek out the experts, the young people who have experienced time and care, the young people who can tell you with transparency and true expertise what exactly needs to be changed. Seek out the older adults who can tell you with certainty that the system that deserted them 30 or 40 years ago has not changed, not one bit. If you're truly committed to doing the work, I challenge you to know your weaknesses, step aside, and let the true experts, my fellow brothers and sisters in care, in the positions of power to show you the way. Thank you.
What an amazing group of speakers we have. Dorothy, Professor Roberts, you've listened to 4 people respond to your own remarks. Let me give you a chance to say some comments of your own, and we'll see what others would like to say to each other. Hopefully we can get to a few audience questions, so please put some in the chat if you on the bottom of your screen if there's any question you'd like asked of the panel. Dorothy.
Sure. Thank you. Thank you, all 4 of you, for such rich comments and reflections. Each one added so much to our discussion, and I will try to be brief. I was taking notes as you went along, and I have pages and pages. We only have till 8 o'clock, so I'll try my best not to go on and on and on. So I'll just comment on some things that struck me. And I'm looking down because, I wrote my notes on this. Gwendolyn, thank you so much for bringing up the point about the 2 arms or hands of the state, the social welfare arm and the punitive arm. And I think it's really important to think about how both of those exist at the same time and how they're related to each other and the implications for social policy. So one of the aspects of US policy that I think helps explain our current dilemma, our current tragedy, our current predicament is the way in which social support has always come at the cost of punitive controls of certain communities. In other words, there's never been a time in the United States history when there was just domestic affection, just a generous state. It's and one of the points that Elizabeth Hinton makes in her prior book is how when the U.S. was going to have a more generous social system under Johnson and the war on poverty, it came along with the war on crime. And so, the punitive arm tends to, in each time there's some effort to expand the welfare, they come in to crush it. And similarly, in the 1990s, with the decimation of the federal entitlement to welfare, well, worse than the abolition of the federal entitlement to welfare, that came along with calls for even greater crime control and greater containment of Black communities. So there's always, I'm agreeing with you, this aspect in which in order to have any kind of social welfare policy in the US, there's the thought that there has to be along with it this brutal punitive containment of communities so that they, certain communities, Black, Brown, Indigenous communities, don't benefit from it. But also, as the welfare state shrinks and these same communities are the ones that are hurt the most, that the response is even more intensive containment and punishment of them. So I really appreciated that. Also, I appreciated your pointing out the central role of devaluing Black mothers' childbearing and care for their children in all of these policies. And I think that emphasizes the point that these policies target Black mothers and therefore make them suffer, right? But also, their targeting is a way to uphold these bigger policies that affect everybody and make our nation, a stingy, brutal, cruel nation with policies that emphasize punishment instead of care. And I think that was really important. I appreciate you for bringing that out. Laura, I so appreciate what you said today, and also in your book, Taking Children, your way of framing family policing policies, the child welfare system, foster care, as a direct response to liberation movements, the Black liberation, Native liberation, and also liberation movements in other parts of the world. And I think that's such a powerful way of challenging the view that these systems have anything at all to do with protecting children, saving children. It just emphasizes even more that they are weapons of destruction, weapons of war against communities, in an effort to try to tamp down liberation efforts. And I think that it adds such an important dimension to the politics of these systems. So when we talk about how children are weaponized, these are these are strategies of war, right? So I really appreciate that. Also your point about how the compromises and trying to work with the system lead to increasing the system, taking away more children, making it more cruel, more powerful. I think those examples that you gave really point out that we can no longer try to fix these systems, and also give us examples of resistance in the past, which your book also does, which I think is, the historical lessons are so important. So the lesson then, I think, emphasizes what I was saying about whatever steps we take cannot be steps that try to fix, tinker with, collaborate with, cooperate with. They have to be steps that shrink the power of the system, that decrease contact that families have with the system, that decrease funding for the system. I think those are important lessons. And also your what you said about Native tribal communities fighting back as sovereign nations was so helpful in thinking about taking, a really solid abolitionist stance. How do we keep these state agents of destruction out of our communities? I think that was very enlightening and illuminating as well. I really appreciated how you added the idea of transgenerational impact. That's something I've been thinking. I didn't mention it in my talk today, but I've been thinking a lot about how generations after generations of Black children have been affected by this system, where you have children who grew up in foster care having children who are then immediately taken into state custody by the foster care system, and how that is in two ways such a condemnation of the system, both in terms of the long-lasting harms that you pointed out. This is not past history that is, continuing to cause trauma, because we remember it. It's current trauma that's being imposed on each successive generation. And that, to me, condemns the system, both because of the harm that is so long lasting and persistent and relentless, but also because this is a system that claims to be improving the lives of the children it takes. And yet, it's taking the children of the children. So clearly it didn't do what it said it was going to do. Clearly it has worsened children's lives. It hasn't improved them. It hasn't ended the cycles that they talk about. It's created the cycles that then they manufacture and then blame the people they've harmed for creating the next generation that they can take the children away. I mean, it's a vicious, horrific, perpetuating cycle that we have to intervene on and stop. It's just so infuriating and perverse that they cause the harm and then blame the people they've harmed for the next generation of you did it. And that becomes the justification for continuing it. Also, your point about the Truth and Reconciliation Commission, I think also added to our discussion the idea of innovative, non-dominant ways of holding people accountable. Now, in your case, it was holding the state accountable, but we also can think about these ways of restorative justice as applying to harms committed to children in families and other, among family members, as a more innovative and effective and just way than taking children away and caging people. So I thought that was very helpful as well. Thank you so much, Leda. Did I pronounce your name correctly? I want to make sure I said it right.
Yes,
Leda, for your comments as well. I really appreciate it. I'm so happy that we have a young person who has experience. As you said, you're the expert on this panel. I really appreciate that. And I appreciated your bringing in the aspect of culture and how this system is a way of destroying communities and relationships between family members by interfering with, blocking, banning, devaluing communities' cultures. Also, your point about it's impossible to be culturally competent. I don't know if everybody understood that. I think I understood what you were saying. And from that, I got one point I got from it is that this is not just about training, caseworkers to be more sensitive or culturally competent. this is about fundamentally changing the role that they have. And I thought that was an important point. Also, you raised again the question of addressing harms. And I think it's important to know that abolitionists do not ignore harms that occur either to children or to their caregivers. We're not ignoring that. We want a safer world. We want a better way. The system we have now, it has totally failed because that's what it was designed to do. It wasn't designed to protect children and make them safer and care for their well-being. And so we do want a way of approaching and addressing harms. And I was glad that you raised that and you pointed out the first thing is to think about what are the reasons for these harms. That's what we have to get at, and that's not what the system does. And then finally, just to end, again, I will affirm your point about the importance of listening to people who've been impacted by the family policing system, especially young people who are supposed to be helped by it and can attest to the harms that it commits and be important leaders in this work we need to do toward reimagining a better society that truly cares for children and their families. So thank you, all four of you, for those terrific responses to my piece and all that you added to it. I really appreciate it.
We do have some a number of questions from the audience, and really these could be addressed to everybody. There's, as there always is with abolitionists, especially people new to abolition, there's always jumping to what are we going to build if we don't have this system? What are non punitive alternatives? And I will let people in the audience know that one of the reasons we have 2 days of panels coming up over the next 2 days is because we do have a number of people with thoughts about very concrete reforms. But I wonder if any of you would like to weigh in on addressing needs outside of the punitive structure we have now.
Well, I'm sure we're all good at answering this question. I think we've all thought with it a lot. But I'll just say we effectively have a replacement system in place that middle class and wealthy white folks don't experience the family regulation system. What happens if we struggle with mental illness or drugs or health issues or any number of other things that make it impossible for us to parent, is that we rely on substitute care of our own choosing. We can turn to family members, we can turn to friends, and under extreme pressure, we can turn to institutions that might support our getting better. And so I actually don't think we're that confused about how to handle an alternative to the child welfare system because we have one.
Yeah, that reminds me, I was going to say, and I had written down in my comments to Gwendolyn, because Gwendolyn talked about domestic affection policies, and okay, let's have more of them. We know we do have those policies, right? Let's have more of them. I think that's so true, that there are communities where CPS workers have never entered, right? And it's not the case that there are no needs in those communities. It's just that they have other ways of dealing with their needs. And also, we know that reducing, ending poverty. We know, we have empirical evidence, if you could just figure that out on your own, that providing concrete resources like a check, like what's going on right now during COVID, that all of a sudden Congress is able to come up with the money. Well, come up with that, more of it, permanently, to provide income to people that they need to take care of their children. So there's lots of evidence that just giving families greater income reduces harms to children. So there's another example that we already know. And then there are the ways that prison abolitionists and family policing abolitionists as well are working on within communities, community-based ways of helping each other, so that you see someone in your community in need and you can provide the resources that they need. You simply provide it instead of calling the child abuse hotline. And so there's another example.
Mm-hmm.
And there'll be more, I know. There'll be more.
And if I may add, absolutely, domestic affection. I mean, there is that. For a lot of population groups, that standard does mean something and is actually upheld by the state, right? And does not have a punitive element to it. So, but I think an important distinction to point out there is public and private. So a lot of what happens, which is kind of social welfare provisions, are privatized through employment and so on and so forth. So for instance, things like providing for medical care and health insurance and stuff comes through your employer. So a lot of care that happens is often for middle-class families, particularly, affluent middle-class white families. It happens through employment and through privatized forms of provision of social welfare, right? But what we're talking about now are poor families and marginalized families. So we're talking about, instituting now actual care-based welfare, really welfare-centered as opposed to punitive-centered provisions, but through the public arena, not through this sort of privatized way, which could obviously not be of any benefit to people who are poor and don't have access to that.
Mm-hmm. Yeah, and part of you could stop me when necessary, but part of the very function of the U.S. so-called child welfare system is to push people toward private remedies and punish people who don't have the money for them. And the Adoption and Safe Families Act is a perfect example of that, which of course was passed a year after the welfare restructuring law that ended the federal entitlement to welfare. And in the child welfare arena, where now, all for the first time in U.S. history, there was a mandate to so-called protect children from abuse and neglect, but no guarantee of income to them. And the solution that ASFA had was speed up termination of their parental rights and get them adopted, which to me is a private remedy, right? Just as the welfare law was saying, get married, take a low-wage job, wage job, and stop having so many children. They go together. All of these punitive, stingy, cruel, uncaring policies.
Although it isn't entirely a private remedy, because the money is being funneled into paying foster parents and into giving bonuses to states for adoption. So the increase in the funding of that system, and we did have a couple of questions about the economics of it, the increase in the funding of the system goes to foster parenting and adoption and residential care services rather than to families to raise their own children and to supports for whatever families need, healing from intergenerational trauma, attention to other serious issues that affect families. The funding for that, the moving of the funding could have an enormous impact. As I might add, could the model of a Truth and Reconciliation Commission with an emphasis on the truth part as the first important part of it. Some people attending this evening may have been in attendance in March when we showed the documentary Dawnland, and Cynthia and one of the filmmakers spoke about that. That documentary is not available on the conference website. However, you can find it on the Upstander Project or on PBS Passport, and you can watch the discussion that we had in March about that and see how that Truth and Reconciliation Commission functioned and what it was like for Native children and parents or adults who were taken as children to tell the truth, and to have a commission that listened to that, which Penthea talked about. And I couldn't help but think, listening to Leda, that that really a truth commission for the harms this system has done writ large would be a step towards developing the needs that the services and the needs that families have. I'm afraid we are at the time to close the panel, in spite of the fact that I feel certain we could keep talking with each other for quite a long time, given how fascinating everybody was. This has been an amazing panel. For those of you who joined late, this whole program is being recorded, and the keynote and all of the speakers, if you missed any of them, the recording will be available very shortly after we end tonight on the conference website. So you have an opportunity to go back and view anything that you missed. We are resuming tomorrow at 11 a.m. Come back to the conference website, and we will kick off a day of the first of our 2 days of 4 amazing panels and panelists. So I want to thank all of you who participated tonight, and I look forward to hearing more from each of you and to what our panels in the next 2 days will be able to build on from what you all provided. So thank you to all of you, and good night.
Thank you. Thanks, Nancy.